The observation that we often hear when we begin a conversation like this is about family businesses in particular. It's a cliche, but there may be something to it. Rags to riches in 3 generations. So, Mr. Tucker, how true is that? What I mean at the beginning of this, do most families, when they launch a business, think about the potential minefields a generation or 2 down the road? Or do they sort of go into it, on a kind of a wing and a prayer, and then they look up and say, now what? What's your sense of how this begins?
My sense is that with the founding generation, they have a drive and they have a concept, and they're willing to absolutely put whatever it takes into that first generation in order to make the business work. But I don't think they're looking ahead necessarily and planning to any great degree what's going to happen. My experience has been that over the years, the families then generate in size, and the scope of the businesses change very dramatically and quite differently. And then different types of events happen that cause changes within the business. It could be then the children are born and come into the business. Developments happen, whether some of the kids are talented, some of the kids may not be talented, and they may not be able to actually handle the business in that next generation. When you go to the 3rd generation, it gets even more complicated. And I don't think the founder ever thought through about what would happen with children and grandchildren and daughter-in-laws and cousins. And then when you go into the 4th generation, it's even more removed.
So in that situation, it almost sounds as if at times you're called in after, I'm putting this grimly, after the plane has crashed, not at the takeoff. And is there a sense in which when a lawyer is involved 2 or 3 generations on, when the families are at war, that what your best thing you can do is triage, limit the damage, that is trying to find a kind of comprehensive, everybody will feel good solution is just beyond the pale?
Well, Jeff, what we try to do is if we have a chance and we're there at the beginning, we try to offer terrific planning and basic planning around what to do in thinking ahead and thinking about succession planning. But we don't always have that luxury of being there at the beginning and doing the planning. And in some cases, if the plane has already crashed, we're left with very, very difficult circumstances. And sometimes we're very limited because if the case is heading toward court, or we're in a minority oppression case or a deadlock case, we're going to be within the constraints of the court system when those cases litigate. And those cases can either end very well with good settlements or sometimes not as favorably. But sometimes we even try to use techniques, even such as breaking up the companies tax-free with divisive reorganizations, which is a great result if you have the right situation for that family. But in some cases, unfortunately, and it harks back to the earlier panel, in some cases, it really is search and destroy. And some of these families, when they litigate, they will literally, because of the emotions released, try to destroy the business.
I should mention, because I should have at the outset, that we have explicitly ruled out in this conversation the issue of divorce because it is so fraught with so many of these issues that it would dominate the whole panel. However, my daughter is a matrimonial lawyer. Sitting here tonight, if any of you get into really bad fights with your spouse, would you just let her know? Rabbi, now this is a field in which it seems to me people turn to you on a lot of grounds. But let's stay with the idea of a family business. Let me start. How do you approach this? Do you approach this as somebody learned it in the law, or do you approach this more as somebody who's seen a family at potential risk and is looking to see if they can somehow get out of this with the family and survival?
Well, these really aren't 2 unrelated approaches, the truth be told. If you can put the family back together, then of course a lot of the problems, I assume, will fix themselves along the way. First and foremost, I think that Glenn made an excellent point, that if you can plan ahead of time, that saves most of the problems. This is a case where attorneys are very helpful. Not that they're not helpful otherwise. It's interesting. When I used to be an attorney, back in the day, I'm now it's like Attorneys Anonymous. I used to be an attorney, but I'm better now. I was in-house counsel, actually, for MetLife. And as such, there was a lot of involvement of planning ahead of time. And that's the type of thing where you really can do a lot of good. That, again, it's very hard to distinguish. Is it a matter that there's a financial issue that's leading to a family split? Or is this a case where there's a family split which is showing itself through the business? I think that's an important first step. If you could really weed out and figure out what is the issue, that really will determine how you go about it. You really want to fix the real problem and hope that the other one will kind of follow along the way.
And along those lines, we frequently ask the families who are in our office, what is your objective? What is it that you wish to achieve? Is it family preservation? If it's not family preservation and there's some other goal which is a business goal, and they're willing to sacrifice the family bonds, that's a different story. But these cases are so sensitive in the planning to achieve these clients' goals, because in many cases, back to what you said, Robbie, it's all intertwined in a way that it's very difficult to dissect it in a perfect way to get to that absolutely perfect result.
Judge, how much does a judge alter his or her thinking about a case when there's a bitter family fight and it involves family? Is it any part of how you think, or do you say, that's just irrelevant, we just got to look at the law and see what the law says?
Well, I've been searching my mind, and I pre-read these materials a couple of days ago, and just can't recall a controversy like that I had to deal with as a judge. But the very first case I was involved in as a lawyer, as a brand new associate at Pitney, Hardin, and Kipp in the late 1960s, involved really a perfect storm. Once again, it was, in this case, first generation moving to second. That quickly, if you will. I'm going to keep names out of it, but it was a highly successful commercial real estate business in Newark at the time. The father who had built this business, now moving on into his late 80s, couldn't let go. One of his sons had opened a branch in another state, which was extremely successful. His daughter had married a man who was extremely able as a businessman, but not particularly interested in this business, and in fact really wanted nothing to do with it. And the other son, the youngest of the three, essentially had been a parasite throughout things and had really expected complete entitlement to the Newark branch of the business without having either any ability or making any effort.
He was Fredo. He was Fredo.
I'm not sure.
Okay.
Anyway, we represented, of course, the most virtuous party in that, which was the successful businessman out of state. But one thing I noticed, and this thing really was mean, and had all of, the mother, of course, was distraught. She didn't know what to do and was really perhaps on the verge of some serious problems because she was in her mid-80s as well. But one thing I noticed was the manner in which Judge Robert Matthews handled this case. Many of you knew Judge Matthews, I'm sure. Most of us in his appellate work, but of course he sat at the trial level first and was an absolutely wonderful chancery judge over in Hudson County. And he had a kind of a soft hands approach here that at least kept the lawyers talking to each other and relatively cordial to each other. Essentially I was second or third chair and just kind of sitting back and watching what was going on there. And I really marveled at Judge Matthews' technique. I left for the U.S. Attorney's Office in 1969. The case was still pending at that time, and I couldn't tell you the ultimate result. But it did point out the fact that even right off the bat, when you may have initial expectations about, oh, my sons are going to take over this business and they'll let it grow and so forth, those things can come a cropper. And perhaps in that case, even the best documents wouldn't have been honored.
And also, Jeff, the thing you can't expect, you really can't ever anticipate, is that you're going to have a child or grandchild that has an alcohol problem or a drug problem or a psychological problem. And here you have employment issues intertwined within these families, particularly second and third generation, where you may have a dozen family members employed. And you may have family members that are really in trouble, but the founder and the patriarch or matriarch never anticipated having this kind of situation where it's all combined.
I want to pick up on a different point and then get your reaction and yours, Rabbi. Yeah, this comes from my business, because it's a question about a family business that a generation or two on raises an interesting question. I'm thinking of the family, I think they're the Bancrofts that owned the Wall Street Journal. And it was a family-owned enterprise, and they were never going to sell. By God, when Rupert Murdoch came around with his money, they were never going to sell. Not the first time. And then it turned out that some of the Bancrofts never wanted to sell. But others of the Bancrofts were looking at the premium over the stock price that Rupert was going to pay, right? And as we now know, just enough voting interest from the Bancrofts went with it that Murdoch now owns the Wall Street Journal. So the question I have is, first of all, could an older Bancroft have prevented that by writing in highly restrictive limits on how this equity could be dealt with?
Certainly, in the earlier stages of the planning, when the shareholders' agreements and the different agreements were being drafted, there could have been restrictions on voting and non-voting, and voting only with respect to certain transactions. So it can be done.
Is that what I think the Sulzbergers have that, the owners of the Times have exactly that.
Where it's truly a family heritage and legacy, and it's treated as a dynasty, and the sacrifices that are made by that particular family for that business, it's really very, very unique. But the fact of the matter is, many of the cases that we deal with, the documents, as the judge said, sometimes they just don't work. No one anticipated the law of unintended consequences. And in many cases, our clients come to us, there are no agreements, and we're dealing in a vacuum. There never were shareholder agreements executed.
In the absence of this kind of world, take us through how you might look at a case in which something like what I've just described comes to you, and we know what the founder would have wanted, but what we've heard is rhetoric. There are no documents, there's no proof. Half the family wants to get rid of the business and cash out. The others say this is a betrayal of our grandfather. Everything he built is lost if we cash out. How do you deal with that?
So it might be morally or ethically important to follow what the founder wanted, but legally not at all. Once inheritance happens, the father, grandfather, great-grandmother, whoever might have started it, no longer cannot control from the grave. Now, legally, perhaps a very smart lawyer could somehow keep that hand holding on from the grave, but that's another question whether that's a good idea or not. As Glenn keeps on saying, you don't know what's going to happen in next generation, even a little less 2-3 generations down the road. So even though it could be arranged, I don't know if it's particularly a good idea. There comes a time where life moves on, and it's time for the new generation to make the decision.
Which leads me to the reverse point in a family business. Let's take the situation where the younger generation is saying this family business is dying. We've got an 8-track founder in an MP3 world, and he just doesn't want to change, right? He's a famous restaurant owner who got into this in New York. Now, if the founder has retained a kind of control that threatens the future of the company, what's the recourse of the younger generation in that case?
Well, I can draw on a personal experience within my own family where the matter was resolved without the need really for controversy. For the first 2 generations, beginning in the early 1900s, this family business in northern New Hampshire had been a lumber business. They bought their lots, they cut their trees, they floated them down to their own mill, they cut rough board lumber and shipped it on the Boston and Maine Railroad to Boston and sold it and did very well until the major giants, if you will, in the lumber business, the Boise Cascades and the Georgia Pacifics and so forth, essentially were able to underprice them even in a local market. And while I didn't know the older of my 2 uncles, the younger one I know was really very concerned about what was going to happen. But he had 2 very able sons in my generation, and they sat down and talked to him at some length. And they said, Dad, basically, the lumber business is not going to cut it anymore, but we have some extremely valuable land here. New Hampshire is about to take off development-wise. We know how to manage this property. It's not going to be cut and slashed like they did in Killington, Vermont, or places like that. We can do this. We can do it right. But let's become a real estate company. And they did. And they wound up building two very good ski areas in northern New Hampshire, along with housing developments and so forth. Opened up a real estate agency as a part of that. And the other son, who was very good with heavy equipment, opened up a road construction company, all under the family name, which had high visibility and high recognition and high value in northern New Hampshire. So there's a situation, at least, where that type of transition, as reluctant as in this case, the second generation might have been, worked.
Now, that's a happy ending.
I have a story where a fourth
Please.
generation, in a fourth generation, one of the great-grandsons decided he was going to break away and compete with the family business, and he did so, violating non-competes and other agreements, and violating the family trust. There was a lawsuit, and the company won, and despite winning the lawsuit, the settlement that was put into place was to put enough money in the hands of this young man to get him to start his own business in an unrelated business for the good of the family, for family peace. But the flip side of all this, I think it's a more interesting question, is what if the senior generation says, it's not the business that isn't working, it's not that we're not able to keep up. What if they say, our children can't run this business. We need to sell while all those children and grandchildren are employed. And the children and grandchildren may not agree with that because they want to create a family office.
But I assume the outcome depends on what the structure of the company is, no?
It does, but it's a fascinating dynamic when the families come in to be counseled on this. And frequently it can take, the last case that we had like this, it took 10 years for that decision to be made. And the CEO made the decision. And the CEO, back to what the judge said about mom having difficulty, the CEO is not the CEO as we know it. It's the chief emotional officer. It's the mother.
Thank you. Speaking of family businesses, I assume that occasionally these kinds of rifts develop in law firms. Yeah? This is what's called a pregnant pause. Are there special circumstances in a law firm that is it's Smith and Smith, Goldberg and Goldberg, whatever, that have a special emotional or a special circumstance? You can, again, take your best shot.
I had a case once, a fascinating case. An attorney was suing a client for monies owed, and the client's defense was that the attorney just really did not do a good job. Sounded like a pretty run-of-the-mill case until we found out what the case was. It seems that the client's brother had stolen all of the parents' money shortly after the parents passed away. He signed checks fraudulently, cleared out the banking accounts. And the brother went to this attorney and said, I want you to get my money back, but I don't want my brother to go to jail. I don't want you to sue him. And what ended up happening was the lawyer did a very good job. He sued the banks and said they should have never honored those checks. They knew the people were dead, and as such, he wants the money back. The bank obviously went with the defense of, you know who took the money, we know who took the money, go get it from the person who took the money. And they won the case that way. What was fascinating about this case, which went on for a very long time, was, again, it's similar to your case, to the extent where this is the reverse dynamic, where you're having a very acrimonious case, but at the same time, you have this overarching concern for family. That, I want to win this case, I want to have my money, but family is still family. And that was now the case became ridiculous as time went on, because the same brother agreed to a settlement under which he gave $250,000 worth of collectibles to the first brother as partial payment. The brother knew nothing about the collectibles, so he got a dealer to come, take it in, and said, take 10%, just sell it all. And then the dealer got arrested because that was given over. It wasn't actually the brothers.
I love the law. But let's continue on with this. I mean, go ahead.
Because I want to
Yeah.
just follow up on your, specifically about law firms.
Yeah.
One of the things we find very interesting in family business work, it does correlate to some of the breakup work that we do, particularly when the bonds are breaking. There are a lot of correlations when you're breaking up a professional service firm. Many of the same kinds of underlying emotions, the intensity of the relationships, and a lot of those things do carry over, and we do find there are a lot of direct analogies in counseling in one area to another. The professional service firm in particular is directly analogous, I think.
And that's another sense in which we're one big family, but it's not quite the way that sentence usually is supposed to mean. But this, I keep coming back to this issue of if you're in a lawsuit, it's bad enough. I mean, it's just not a happy time. But if it's a family that's breaking up, I can only assume that the pressures, not just on the litigants, but on the attorneys themselves, must be geometrically larger in trying to handle not just the case, but the emotions that sometimes probably go back literally into childhood.
Well, there's no doubt about it, and you can see it in cases that do involve high levels of emotion and all sorts of types of litigation, and it does play on the attorneys. And once again, from my own experience as a practicing lawyer before 1978, I had a couple of cases like that just tore my guts out in the course of it. And you say, well, gee, this is a commercial dispute, it's just about money. Well, it got to me, I'll tell you that, because of some of the personalities involved. I think one of the things that a judge can do, particularly after you have some experience and you recognize what's going on in front of you, whether it's at the motion stage or conference stage or even at the start of a trial, is that if you notice that the attorneys are under stress for reasons unusual, if you will, or because the nature of the controversy makes it more stressful than might otherwise be the case, I always felt a duty to try to deal with that and to try to help lawyers deal with that. A judge helped me that way years and years ago in the case I was referring to before, and I never forgot that. And so that there can be some palliatives involved that you can bring into play to help lower those levels and allow the case to proceed on a more even keel. And I think if a judge kind of stays out of that or divorces himself from that too much, you're not really doing the service that you could.
Along those lines, we have adopted a technique in some cases where it's appropriate. We bring in a business psychologist who specializes in family business. 100% of their practice is restricted to family businesses. And they come in some cases, and they're able to actually counsel the family. In some cases, the cases will come to our office. I'll send them to the business psychologist first to see if there's solutions out there from a psychological standpoint. Independent psychologists, maintaining total independence from our firm and from each one of the family members. And in some cases, we've had psychologists who have been able to fashion all kinds of systems and relief. That's been a tremendous help to us in parallel to the law case, providing us with a tremendous relief of a lot of that tension, which is then placed into these psychologists' hands.
What's fascinating about that is that, I come from another generation of, as I guess we all do, of how we were educated in law school. And the notion that another discipline might be invited in to counsel lawyers, masters of the universe, I can't ever remember even approaching something like that. And what it sounds like to you is what would really help in matters of family business if the lawyers recognized the limitations of the law.
No, there's no question, and some of these issues are so deep in terms of sibling rivalry and other issues that we really are not equipped to deal with some of the underlying issues.
Is this a familiar pattern that comes up with you, that you actually bring in non-lawyers with other disciplines and saying, we need your help here?
Absolutely. I mean, particularly if an attorney is dealing with a child custody case, I think there's no way you can go forward without some psychological help, someone who really understands the dynamic and can really advise you in the correct way. Certainly any abuse case, you definitely need someone like that. And it's no different. I recently sat on a patent case. So all attorneys know that there's patent attorneys and there's everyone else. And as a member of the everyone else, I knew very little bit about it, and we had to bring in experts, not just technological experts to explain the product involved, but also patent attorneys to explain to the judge, that this is standard and this is not.
You had
I think from a judge's point of view, we would welcome that type of initiative and that type of assistance. I mean, it's not just that we love to settle all our cases. I mean, as you know, 96% of them settle anyway, so it's not as if we're necessarily looking for that. But here's a situation, though, where justice or an appropriate and workable result with the least amount of acrimony can possibly be found. And I can't imagine a judge not welcoming that type of initiative, once again, if there were some time limits on it and so forth, so that it didn't either derail the case or delay it unnecessarily.
Jeff, another thing this is unrelated to family business, but the United States, I think, is alone in the lawyer being the lone wolf, because around the world, in many countries, many regions of the world, multidisciplinary practice is in vogue and has been for many years, with combinations of many professionals together with lawyers in order to affect the result for certain types of clients.
Why? Why are we the lone wolf?
I think it's been the nature of the historical practice of the way jurisprudence has grown up in the United States and the independence of the organizations or our regulatory bodies, federal and state, and also I think our associations and different groups, affinity groups, have kept us along these lines and seem to fight it over the years, fighting any notion of this multidisciplinary practice.
So the thing that's normally stated more publicly on that point has to do that the RPCs rather strictly govern the conduct of attorneys,
conflicts,
whereas while other disciplines may have their own rules of one sort or another, they're not as stringent as ours. And the thought being that a multidisciplinary practice might lead to divergent levels of conduct or divergent types of approaches from an ethical point of view that could be troublesome. Now, I don't know if that's either insurmountable or even accurate, but I know that it's perhaps the most often expressed reason against it.
Well,
Okay, yes,
I'll just
take the last
comment-
one.
I'll just comment that's maybe true in many cases, but not in the area of mental health. I think when it comes to mental health professionals, their rules are very similar to ours, and in fact, that's, I would imagine, in my experience, probably in yours as well, those are the people you probably want to lean on the most. And you end up at the attorney-client privilege is also privileged when they talk to their mental health professional. So really, I think that works out particularly well.